Hi everybody, I'm Eyal Bressler. Thank you all for coming. Thank Dr. Dana Baron, chair of this course. We'll talk today about patents. Okay? Now, if you have suggestion, question, everything will come gladly. Just call me, Eyal Bressler, COL. I'll be there. Ask me question, I'll try to answer. So we'll talk today about patents. Patents are a very narrow area in a wider area which is called intellectual property. Now, intellectual property, we'll explain what it is. It's one brick in a path of the money. I'll explain what is path of the money. If you want a VC fund to invest in your technology, so they will look who you are. They look for the team. Now they will look what kind of patents do you have, and they will try to understand which technology is protected by your IP, by your patents. And then they will resolve the market coming from the technology, coming from your IP, coming from the team. Okay, so it's a long path. Now everything is coming towards the regulation. And we'll talk today what is regulation. So if you have questions, just wait 5 minutes. So about the legal system. I'm talking about the Israeli legal system, but the legal system is, you can share it all over the world. The legal system comprises of constitution, which is the ethic guidance, what we can do, what we should not do. And under the constitution, there are laws. There are many, many laws. Now, two kinds of laws are relevant to us in the property law. It's the real estate property, mekarkin in Hebrew, and the personal property, which is metaltalin in Hebrew. Now, I'll try to explain what are the real property and the personal property, just for you to understand what are patents, okay? So it's not a course of law, it's a course of patents. So I try to explain. Now, in real property, everything that is connected to the ground is a property. So a tree is a property, a building is a property, a land is a property, okay? Now, you cannot own a property unless you register the property in the book towards your name, okay? If Eyal has an apartment in Ra'anana, so it means that he has a registration, a book says this apartment belongs to him, okay? Now, there is a book for any property. This is not the case in personal property. Now, this is the university property, okay? There is no registration that this marker belongs to the university. There is no book for that. Now, this is a personal property, and land is a real property. But both of them are real properties. Now, what about my reputation? Let's say, hypothetically, that I have reputation, a positive reputation. This is not tangible. You cannot touch it. This is intellectual property. Okay? So we talked today about those intellectual properties, and they are divided into two. A family of properties which are like real properties, which have a book, which have registration. You have the patent book, you have design book, breeder's right book, trademarks book, etc. And there are kinds of intellectual properties that you have no book, like this pencil, like reputation, copyrights, and it's written there, copyright. One should be trade secrets. Okay? There is no registry for trade secret. It's just the opposite. Until now, we understand in a few words what are intellectual property. There are other properties like trade dress properties. If you enter to a shop and you want to drink coffee and you are in a black, kind of blackish place and you drink your coffee, you should be in aroma or something like that. It looks like aroma. You should not read the name aroma, but you are there. And if you want to eat something, so you go to a orange labeled place and you invite your hamburger, you should be in McDonald's. Now, there is no really one property to say this is aroma and this is McDonald's. It's just the gatherness of everything. Patent, trademark, trade secrets, and everything together. This is trade dress. Now, we talk today only about patents. The full name is utility patents. But what is the word patent? The word patent, what it is. Now, the Israeli law does not explain what is a patent. So I'll try to to go to the book of Esther, Megillat Esther, because we are just before Purim, and you'll see that when the king wishes to kill all the Jews here, in a few pages later he wants to save all the Jews, but if he wants to kill all the Jews, he sent a letter. He sent a letter, it's written in English, he sent a letter, written, and it says, everybody will get this a copy of writing. He should do something. Now, it's not a judgment. The king does not say, today we'll do something. He writes it in a book, and just in a moment he writes it on a book. This is a forcible law. It just is today in our law is forcible when the prime minister signed it, and it's published in the book. So a patent is like said in English, in Hebrew, pat shegen. Pat shegen aktav, it's just say patent. It's come from Sanskrit, translated into the Hebrew. So patent is in our Bible. It says something which is published. The opposite of patent is latent. Latent is not published, and patent is published. Okay? So understand what the word patent says. And what I says about patent, this is just, I wrote it. Patent is a property right. It's a real property right, if you now understand what I'm meaning, given by the state within the territory of the state to the patent owner or owners to exclude others for commercializing a specific technology which is claimed in the patent. What is claimed, we'll see. For a given time, you can get a patent up to 20 years. Thus, patent is a negative monopoly. It's not a monopoly of the government to do something. It's a monopoly for the individual from the government to exclude somebody to do something. If you have a patent, you have no right to do nothing. If you have a patent, you have a right to exclude other, to avoid other, to provide, to eliminate other for doing something. You get it? Okay. Now, upon the TRIPS is an agreement, treatment that all the countries are signed on. According to the TRIPS treaty, all the patent laws in the world are just the same. So I show here the American patent law, but it's just the same like the Israeli law. Okay. So Article 101, just in the upper scene, says that patentable technology is something which is novel and useful, new and useful. Now, chapter 102 say an objective criteria of what is new. Objective criteria, what is new, is something which is not published before the day you file the patent. So if I file today a patent, everything that was published up to yesterday is period art, and it gives my patent. Okay? So it's very objective criteria. You just read an article, says if it's just the same. If it's the same, your patent is dead. Now, Article 103 says something different. This is subjective criteria. Says there is a person who is ordinary skill in the art. A guy which is ordinary skill in the art. It's called fushita. Person having an ordinary skill in the art. Now this fushita, this person is reading all the articles all over the world, all the times. Now if he understands what you're doing, and for him it's obvious, your patent is not a patent. This is subjective criteria. And your patent now should be useful, should be novel, and should be with inventive step. Should not be obvious. Okay? Those are 3 criteria of patents. Now just let's play a game just to be sure that we know what is new. Now what is new is very easy, because if you have published if publication just before, day before, you're dead. So let's talk about non-obvious now. Now this is a chair. This is a real regular chair. Now this regular chair has substantially horizontal seat, and let's say four legs interconnected to that seat. Okay. Now, if I want to file a patent, a new patent, when I know there is a chair, so I should have improvement. The improvement is very easy to be understood. Now, the first chair I show you, has 0 degrees of freedom. 0 degrees of freedom. It cannot move in the XY, in the planar area, and it cannot move up and down. It cannot do nothing. It's just sitting there like a seat. Okay? So if I change one of the criteria of his freedom to operate, I'll have a patent. So, and one idea, from 4 legs to one central leg that can go on the z-axis up and down. Now he has 1 degree of freedom going up and down on the z-axis. Now if I want a new patent, I can have wheels, and it can move toward the x and y. So another patent. Okay? Now let's say there is a patent that we know about patent that can move up and down. Can we have another patent just on that? Yes. We can have a second patent of a rotation around the zeta axis. Okay? Everybody is with me? So the improvement here that is it can go in a rotational manner. And I wrote a claim, very funny claim, but I just wrote it. A claim. Claim is a definition. I defined my new improvement. I defined this improvement. My definition is a furniture useful for sitting, because it's a seat. It comprises, what it comprises? A and B. It comprises a raised substantially horizontal surface, and it comprises a vertical leg. The vertical leg is not new. We know that there is one vertical leg. This is not new. What is new? That we can rotate it, swivel it. So I wrote the word wherein. Wherein says this is new. Wherein says this is new. Wherein this surface is rotatingly swivelable around the leg. The improvement here that it can rotate. So the word wherein says from here it's new. So there is general approach to write patent and to read patents, to read their definitions, or in other language, to read their claims. A is something useful for something comprising and B, wherein the new or novel or non-obvious feature is something. This is the way to write and to read patents. Now, after I wrote my funny patent, I make a search. And in the search, I find another patent. And this patent by William it was filed in '87, has many centers for the rotational of the z-axis. So it has another way of looking for freedom, degrees of freedom, so it can have a patent over me. It's ever and never-ending improvements way. Now let's talk about the very boring and stuff calling the timetables. Very boring. I try to do it as fast as not boring as I can. Now, each patent has 3 stages in its life. 3 stages. Okay, like a butterfly has 3 stages: a caterpillar, a cocoon, and a butterfly. So it has 3 stages. Now the first stage is called Paris Treaty. Now Paris is very nice place to be. Okay, so Paris Treaty is the nicest stage of the patent. If you file a patent, even though you file a patent only one territory, let's say in the United States or Israel, your priority date, the day of your filing, is registered in all the books all over the world. So it's worldwide. This is nice. It's very cheap. It's cost-effective, very cheap. The fee for filing a provisional patent application is about $150. This is not so expensive. The person who files patents wishes to have time to market. Now the patent is filed, but nobody will publish what you filed for 18 months. So you have time to market. So this is the unpublished section, and it's flexible. I wrote a patent about this marker, but I didn't write that this marker is selected from green, black, and blue. I can do it in 1 year course. I have flexibility to do it. Okay? in many cases, when you file a patent, you know the core of the invention, but you have no further embodiments where to show your patent, and you have 1 year to do it. So Paris Treaty is a nice part of the patent, and then there is another step, it's called Patent Corporation Treaty, and then the last stage is the national phase. Now, about the national phase. After 2.5 years, the patent will come to national phase. You should file it every nation and nation, every territory and territory. This is very expensive stage. So this is not cost-effective stage. It's very expensive step. Your patent is not worldwide, is national-wise, is published, and is not flexible at all. Okay? Now, when you file a patent, it's only application. After a few years, about 5 years, the patent will be examined and then will be approved or not approved. So the procedure to prove a patent is very long and very long and expensive to you, very long and expensive. There is a first non-final rejection, there's a second non-final rejection, there's a third non-final rejection, there's a fourth non-final rejection. Every final rejection is about $5,000, okay? And at about 6 months. It's very, very long and expensive. And then you can fight continuation of this patent. So a patent will cost you in the end, if you file it in the States, in Europe, about $60,000, something like that. It's very expensive. And there is another way of getting a patent. That was the US way of getting the patent. This is the non-US way to get a patent. You say something to the registrar, he says it doesn't agree. So you say something else, so it doesn't agree. In the way, you agree with each other, and the definitions, the claim are set forth, and you have your patent. Now, I told you just before what is the administrative timetable of a patent, but the patent has another timetable. I'll be very brief here. This slide will be, we spent enormously time on that on the third lesson. When you have an idea, you're just showing that it's working because the patent should be useful. You're showing that it is working, and then you file a patent provisional, a patent application, and then you think to yourself, okay, what I can do with this idea? And you're doing a market research, and you're performing a product alpha type experiments. I'll explain what is my alpha type. Alpha type is a product which is really work. It is working. If it is working, it's alpha type. If it's not working, it's not alpha type. It should work. Now, if we're talking about biology and medical devices, you should file then a PCT. We just explain what is PCT, is another step of a patent. And then you're doing your beta product. I explain what is my beta product. Beta product is a product which really works. It works, but it works in the way that you produce it under regulation. So the difference between alpha and beta is the regulation. Okay? And then you've got FDA, and then you have the cells. So the real timetable when you have certification of the views about patents, you see there are two views. One view is in the first 2.5 years, the patent is very cheap, is worldwide, is unpublished, is favor the patentee. But after 2.5 years, the patent is very expensive. Now, not all the people who are having the R&D finish the R&D in 2.5 years. So there is a gap. This gap called in the literature the valley of death. Because most of the patents, say half of the patents, 50% of the patents are dead in the day 2.5 years, because the patent become to be very expensive. Nevertheless, the R&D didn't get any money for supporting the patent. So after 2.5 years, you are going to look for money, and they will look for your team, which patent you filed. They'll see the technology. They'll see the market coming from the technology coming from the patent, and they'll see what's the regulation, and then they'll decide if you are dead or not. So just a few words about regulation. Just a few words. Now, I'm not expert for regulation, not at all, but I'll try to explain what I'll define a regulation. Regulation about, let's say, FDA regulation or CE regulation, ask you 3 questions. I ask you to provide them 3 claims. One claim that your product, your formula, your device is safe and is useful. Efficacy and safety. You should provide the regulation, efficacy results and safety results. This I will call PMA kind regulation. A second kind of regulation, it's called 510K regulation. It's just asking you, are you safe? Don't tell me that you are working. I don't care about that. I don't care about your efficacy. I don't care. I do care about your safety. So it's very easy to show you that you're not killing somebody, much easier than show that you are helping somebody. So this is the 510K branch. Another branch, you see here an example, is a third branch saying nothing about your efficacy or your safety, saying, I'm like him. He gets something. He got a 510K, he got a PMA. I'm like him. So you should provide evidence that you are like somebody else, and then you got your regulation. This is called substantially equivalent regulation or SE regulation. This is my way of looking for regulation. So if I'm too general on that, if you see this device is known in the art. It's nothing new in this device, but the U.S. Navy, I think, produce it in special aluminum material which are very light, very strong, military kind of aluminum. So they've got their patent about this device, but the patent is the material. So they just show that this device is just similar like other device which looks the same. This is SE regulation. Now, this laryngoscope is not so simple device. Laryngoscope penetrates to your mouth and provides you with an airway for patients after intubation. Thank you. Now, this is an invasive tool. Now, see what's happening there. This invasive tool, so the regulation should be something like PMA or 510K. Nevertheless, this is SE regulation. Why is this SE regulation? This is because the patent is about the watch, the clock. You see just in the left side. The American standard says that you can intubate only for the first 30 seconds. Sorry. After 30 seconds, you should go away for the patient, should breathe for him on or dead, to be dead as his own. Don't harm him no more. Only 30 seconds. Now, when you're in the field, you never know what is 30 minutes. So you have a watch here in the patent saying you, after 30 seconds, stop doing what you're doing. And believe me that today, when all the paramedics are with camera in the States, nobody wants to do any harm to your patients, even though it's try to save him. So all the new laryngoscope should be bought with an instrument show you when you should stop treating the people. Now, this is not a new laryngoscope. This is a new watch, and just to show that the clock, the watch, is working for 30 seconds. So it's PMA. Now, you see that the regulation force the inventors for a specific strategic plan that the patent will be on the clock, watch, and not for the laryngoscope itself. The connection between the regulation and the product. I'll just go away. This is 510K resectoscope. It just shows that effector is like other effectors, just 510K, even though it's invasive. This is a stent. Here the stent is just saying that we have a new code for a stent, so it's a 510K, even though it's very invasive. This is another kind of stent, but the claim here is that we have a new type of stent. For that, they should go to PMA, and this is a drug, of course, coming for PMA. Now, why explain to you all those regulation matters? Because I want to talk about money. When you applied for venture capital funds or for other funds, please give me money, you have thousands of competitors, and they should understand why they're paying you, giving you the money, not somebody else. Now, if you say to them, I have something very nice, very small and very nice, like the SE project, having a clock/watch on a device, that says, okay, you will have your money after, let's say, 2 years, 3 years. There is no risk of time. We are not risking our money. Even you ask for very small amount of money, and there is no risk. Even though your present net present value, the value of the device is very low, the risk is very low also. And in drug, you can gain a lot of money, but the risk is high. So when you're coming to a venture capital fund, you should come as much small as you can in the terms of risk, even though your net present value is small. So when you come thinking about regulation, think about your patent, think about the guy who give you the money, who thinks about the market. Do you have any question up to here? Yeah. How much time? Yeah, okay. Sorry.
If I go back just to your 3 ways of issuing a patent.
Yeah.
So the last one is like literature survey. This is what you meant?
No, I meant something.
No safety, no efficacy.
I'm talking about regulation, not patent. Just to be sure. There are 3 different branches. Generally speaking, there are 3 different branches of regulation. One claim efficacy and safety. One claim only safety. And other one be similar to somebody else. It's okay? I'll talk more about this slide. Maybe by this slide you understand me more. Let's think about the guy who's the head of the Israeli venture capital fund or American venture capital fund. He's the head of the venture fund, okay? He's in his role for 2 years. So he's leaving his role in 2 years. What happened with him in 2 years? He will try to find another work, let's say in a bigger venture capital fund. Okay? You are with me up to now? Okay. Now you're coming to him and applied for money. He can think to himself, I can take with my, let's say he's got $100. I can spend $100. Should I spend all the $100 to one medicament? Now, if I succeed, nobody will remember that I succeed because it was 12 years ago. The times to get money from a drug is about 12 years. So nobody will remember who was the general manager who accept this drug. So he says, okay, I want to have something that they know that I'll succeed. So he will focus only moderate and small projects. So if you have a project, you should divide it into very few small steps. That each step is about should be SE or 510K type project. If you have a new drug, your first project will be the system, the diagnostic kit for disease, just a diagnostic kit, because the regulation is very low. Afterwards, when you've got the money for the diagnostic kit and you have your system, you should file another patent about the drug capsule, which is 510K. After you have penetrate the market of drugs in your area, only then applied for a bigger fund for raising a medicament. So you're eating the apple in very small bites, bite by bite, and you're going from the SE to the 510K and to the PMA terms. Now you should file your patents just the same. Here, this is a patent about a drug. The success rate to get money for a drug, it's less than 1%. This patent is a 510K regulation for the success rate to get this kind of project into money is more than 50%. You know, in Israel and all over the world, there are many incubators and accelerators. The chance that you can share with them your idea and they will finance you in 5-10K project is more than 50% if you are the right team and you have the right IP. So in this case, Professor Yosipovich has a new resectoscope. He can ask for a patent for a new resectoscope, but not. It asked for just a new applicator, just a small bite in the technology, got the money from the VC funds for this applicator, and then he produced his device. Other questions? I want to share with you experience of one of my clients. His name is Oded Nachlieli, Professor Oded Nachlieli. He had 3 steps in his success story has 3 different steps. The first step, Oded Nachlieli invited a gauge mouth. You know what is a mouth gauge? A gauge mouth? When you should, it's not a mahzon pe. When you want to open the mouth very, very largely for a long time, if you have diseases in the mouth, there is a gauge to open your mouth. So he invented a metal-made mouth gauge. Now, just think how many products he can sell in this device, this iron-made process. The way we should think is about thinking about Israel and duplicating it. There are about 6 major hospitals in Israel doing mouth gauge studies. So you can sell in Israel, let's say, 12 devices, two per university, 2 per hospital. So now you should duplicate Israel into 60 times, and you've got the US. So you can sell in the US about 600 devices. Let's say, money-wise, that US is half of the world. So you can sell only 1,000 devices ever. So if the cost of one device is $1,000, the overall NPV is $1 million. This is not coming from the money, okay? So the second generation of the device, this device is very successful. Every university has two types of those devices, but only 1,000 of them. So the second generation was a plastic-made disposable device for treating a disease. Now, you're not looking for hospitals, you're looking for doctors. How many doctors are there in Israel? Let's say 1,000. How they are in the US? Let's say 60 multiple thousand duplicated into 2. Sell them 5 times the device cost $250. Now you've got, let's say, $100 million budget. The same technology coming to another thinking, and he got a lot of money. The last stage of him was changing the mechanical technology to a laser technology. Invite an applicator for a laser to treating the disease, and he sells the applicator. So every treatment should buy a device, not a hospital, not a doctor. Every patient, every treatment. Okay? This is the way of thinking that coming from the regulation, coming to the market, coming to the patent, and then coming back to the money. I'm here. In the next presentation, we'll talk about searches. It seems to be very dull subject of why should we search and what should we search, but I want to focus the second lecture after the break to talk about patent searches and what can we understand from them about the team, about the technology, about the market, and about the regulation of products.